Добрий день, мене
Good afternoon, my name is Olha Tamanova, and I want to thank everybody who joins us in Ukraine Media Center Ukraine Forum. It's been 10 years of the war, and today is day 638 of the full-scale invasion of our homeland by Russian aggressor. And now we will be talking on a very important topic. We will talk about the help of Ukraine to the civilian hostages and their families. A little bit of history. It's been a year since the law was adopted on the social protection of the civil hostages and the members of their families. We understand that the Russians started kidnapping our people not in year 2022, but way earlier, since 2014. So today we will be talking about the way this law works, what are the pros and cons, and to what extent are we prepared to protection and help to the families and those who ended up as hostages of the Russians. Let me introduce our speakers today. Joining us in this studio are Tetyana Katrychenko, Executive Director of the Media Initiative for Human Rights. Also joining us is Bohdan Melnykovych, lawyer at the Crimean Human Rights Group, Aliona Luniova, Advocacy Manager at ZMINA Human Rights Center, and also joining us is Anastasia Kalinina, lawyer at CrimeaSOS NGO. Good afternoon. So, Ms. Tetyana, let's talk a little bit about the context. What's going on with those who end up as the civilian hostages before the year 2022? How are those people protected by the government? Does this protection work? And how does it work? Good afternoon, dear colleagues. Let me start with the fact that the Russian Federation started detaining the civilian hostages in Crimea since 2014. People were detained in dozens and hundreds, and such detentions could last from a couple of days up to a couple of months. Then we were trying to agree on setting such hostages free. Sometimes the people were let free, but sometimes we know about the tragic cases when those hostages were killed in captivity, but the occupation was going on. Well, it's going on until this very moment, and it was going on for years. And the longer such occupation was going on, this regime was the longer and the stronger the regime was cementing itself in Crimea and Donetsk and Luhansk regions, and it resulted in the fact that we've lost opportunity to obtain verified information about what's going on in the temporarily occupied territories. And those people who were detained due to political motives, they were in places on detention, not staying there for a couple of days or weeks, but for years. And in fact, those civilians, they and their families were left one-on-one with that problem that emerged back then, and we were realizing back then. And yes, when we talk about the civilian hostages who were detained in the occupied territories, we can say that they are different citizens, because from what we know, the occupational authority has to install their regime which is responsible in occupied territories, and is their responsibility in terms of any criminal offense to detain such people. But when we talk about the civilian hostages, those detained due to political motives, it's a completely different category of people who openly or not quite openly act against the occupational regime, occupational authorities. They wanted their reunification of Ukraine. Why I'm saying openly or not so openly? Because some of these civilians were detained for just posting something on the social network, or in their conversation with the neighbors they could just express their opinions. And also among them there were citizens who were trying in other ways to tell about what's going on in the occupied territory, and all those people who were trying to assist to bringing Ukrainian control back on those occupied territories, those people ended up in confinement cells, in identified detention places, in the cellars, and so on and so forth. And their families, they just didn't know what to do about it. And back in year 2018, the state decided that they can provide assistance to the family members of those who were persecuted due to the political reasons and in connection to their civil, religious, and professional activities. And back then, a commission was created at the Ministry of Occupied Territories that was providing such support to a very limited number of persons, mostly such people who were detained in the territory of either occupied Crimea or Russian Federation. The territory of Donetsk and Luhansk regions was left in the gray zone in these matters too. Why did it happen so? Because the government officials were saying, like, look, if anybody is detained in Crimea, like Crimean Tatars, it's obvious that it's a persecution of Crimean Tatars. Or should someone be detained in the territory of Russian Federation, it's clear that it's a persecution of the Ukrainian citizens due to political motives. And there is a lot of publications in the media in that regard. But if we talk about Donetsk and Luhansk region, there was no such information emerging in the media. Just in the occupational media, there was some information about detention of a yet another saboteur, yet another spy or a terrorist. And the information was coming in very small doses, and when the state, when the government could not sort it out who those people are, why is it the government who is supposed to support and help them? However, the time was passing, and the Ministry of Occupied Territories back then created yet another commission, which included bigger number of people, and back then I have become a member of that commission, and we've started considering or reviewing the applications of the family members of those detained in occupied territories. It was quite difficult because many representatives of the government authorities, they did not understand how to prove the civil activist or political position. However, the process has started, and I think a couple of dozens of families of the civilians detained in the occupied territories of the East were recognized as such, who were detained due to the armed aggression of Russian Federation, and their families received material support. And as of the 24th of February 2022, the list of Security Service of Ukraine included 301 citizens who were considered to be detained due to conditionally political reasons in the occupied territories of Donetsk and Luhansk regions. After the 24th of February, this number is increasingly growing. We cannot say what is the exact number of people detained as long as the occupation continues, and now the state has and had to decide how to help the wider circle of its citizens. Thank you, Mr. Bohdan. We know that the law is in effect for more than 1 year. So in short, what is the help or aid that can be obtained by those citizens who were affected by abduction or kidnapping or other similar actions? Well, as the law was adopted, it just regulated the relations that came into practice earlier, and talking about the types of help and support that such people can consider. I mean, the prisoners of war, the people who were deprived of freedom due to the political reasons, and the members of their families. So first of all, it's a material aid. It can be one-off disbursement paid after a person is set free, or a regular financial aid which is disbursed on a regular basis to the family members of the detained person as long as the person stays in detention. Also, yet another guarantee is the support in rehabilitation that the detained persons and their family members can count on, and obviously it's a legal aid. It's real present for the family members of those who were detained and who are detained in Crimea or are under investigation. For example, such people, during the court proceedings, they need lawyers to protect them, and the family members may apply for compensation of expenses for lawyers in such cases. Among other social guarantees, it's provision of temporary housing. On top of that, people who were deprived of their freedom, they preserve their workplaces. Also, such people and their family members have certain exemptions in terms of acquisition of education. Well, you've mentioned such phrase, political motives, which means that those who were detained by the occupiers, we will still have to prove that those people were detained due to the political reasons, or is this notion becoming broader now? Well, it's a broader notion, because when we say that the people were deprived of freedom due to political motives, we generalize in this case. This notion obviously covers the people who were expressing their discontent with the aggressive activities of Russian Federation, who were in one way or another trying to prove their opinion on the territorial integrity of Ukraine, those who were exercising any journalism activities, human rights activities, which in opinion of occupational administration could harm the interests of such administration. So thus we generalize and we call them those persecuted due to the political motives, but the motives are way broader. Well, we know there is a layer of people who were working in the representatives of Ukrainian government, in the local governments, or in law enforcement agencies of Ukraine. So they fall under those criteria too. Yes, generally so. Ms. Aliona, we've started talking about the commissions with Ms. Tetyana. So what's going on with those commissions for the time being, or all those family members and those affected by the occupiers should go through all that way once again? Thank you, dear colleagues. I would like to make one step back, because it's been 1 year since the law was implemented, and it's a good practice to monitor the way it's been exercised, because what Bohdan said, that those guarantees that are contemplated by the law, it's not necessarily that they are fulfilled on practice. We know about the law on the persons who were abducted due to unknown reasons, and this law was not working for 5 years, so the same case may apply to this law, and it's important for us to say how those regulatory standards are being applied on practice. And in coordination with the colleagues from other organizations, we've decided to make a monitoring of how this law is being implemented, and we'll draw certain conclusions within the year of its implementation. So now we can start talking about those conclusions. definitely it's not the main thing that arises in the process of implementation of this law, and the other aspects can be described by my colleagues as well. Recently, the Ministry of Reintegration was saying that more than 160 civilian hostages in regard of which the fact of freedom deprivation was identified since the law came into force. And we can also say that this practice of review of the cases by commission was established by the law, and this commission includes both civil rights organizations and representatives of government authorities, and they all have experience of work with the civilian hostages and prisoners of war, and thus they can provide certain information to the commission that is necessary for review of those applications and collection of documents necessary to identify the fact of deprivation of personal freedom. And on top of that, on top of analyzing the experience of organizations who work with the commission, who work with the aid to the civilian hostages, because first we oriented that category, we were also in touch with the members of their families, because we think that the law, the target audience of the law, the beneficiaries of that law are also the members of their families who face all the consequences, because when the family ends up in Russian Federation or in occupied territories, you know, we were in touch with those families who are in occupied territories. You see, the law is perceived, or the effect of the law is perceived positively, both by beneficiaries and by those who work with them. So once the fact of deprivation of freedom is identified, or the fact of abduction is identified, all other resources are put to that fact, because if a person spends a sentence of 15 or 13 years in Russian Federation as convicted due to political reasons, the members of their families don't have to come to the commission on an annual basis to prove every year the same thing. So again, civil rights organizations and families, they evaluate the effect of the law as positive. However, many people still don't understand what are the criteria of the work of the commission, what are the criteria to identify the fact of freedom deprivation. Sometimes the fact of detention is confirmed by International Committee of Red Cross, and then it becomes unclear why the fact should be reconfirmed by the family members in front of the commission, you know, because sometimes the people who were persecuted due to the freedom deprivation due to political reasons, they were beneficiaries of that law. But how do we identify that fact that a person is in occupied territories if the family members don't know about that? There are no any evidences of such people being in occupied territories and being detained there. So we don't know whether the person was missing in action or they were abducted. So there are some uncertainties that harm the interests of the family members, and this is why we have to explain the way how it works to those people. And sometimes, due to the mode of operation of the commission, they work in closed mode. It makes the situation a little bit unclear for the family members. However, making their meetings open is not possible because there are such things as personal data discussed in their meetings. So the commission should elaborate their own practice, because there are complicated issues and questions that have no answer in the legislation. For example, if a person is deprived of their freedom, they can claim such support from the government. But if it takes days or months or weeks or years, the Commission should develop all those internal regulations by themselves on how to extend such type of support. Or if persons are under home arrest, yes, they are under home arrest, but they are not in fact deprived of the freedom in terms as we really usually understand it. And sometimes the family members they ask themselves whether they are entitled to such type of help and support. So for the Commission, it's important to talk about their activity, to explain to the family members and to those who were set free from detention. We have to describe it for them, how to submit the applications, what were the circumstances, and how to describe those circumstances of freedom deprivation, of effects of abduction. Because the committee works with the documents, and if those documents are incomplete, if the circumstances of abduction are not clearly described there, the committee cannot undertake a reasonable decision. And the persons, obviously, they can apply once again, but it's clear that it would be better to have all those applications put together in a proper way, so the Commission has to generalize, and they have to act as an entity who practically works on implementation of the law and who can understand where the law should be amended or corrected. They should submit some suggestions about amendments to fill those gaps where the law doesn't take proper effect. Ms. Anastasia, on your end, what do you document and what would you like to say about implementation of those guarantees in practice? I'm sure you have something to say in this regard. Yes, thank you very much. Like Aliona said, we were talking a lot, and we keep talking with those who were set free, with the members of the families of those citizens of Ukraine who are detained in the temporarily occupied territories of Ukraine and in Russian Federation. We were also sending inquiries to different offices and agencies of the government who are responsible for implementation of the law, who are responsible to extend all types of support that Bohdan mentioned. And according to the data from the Ministry of Reintegration, 462 one-off and regular aids were disbursed during the year 2022. Also, there were cases, there were more than 1,000 or 1,400 cases of extension of this type of aid after the people were set free. And this year, the number of one-off aids, aid disbursement amounts to more than 800 cases. We're talking about an amount of 100,000 criminals here. We understand that those detained were usually the men, and their families were left without the people of a working age in their families, because the families usually contain not only wives and kids but also elderly parents. And talking about those detained in Crimea, they're mostly Crimean Tatars, and we were counting it that there are more than 334 children of the Crimean Tatars who were left without their fathers, including 228 under the age of 18 years. And it's only about Crimean Tatars, but the figures are way bigger, and not only in Crimea. So this matter of financial support for the kids, its amount, it's still a matter of discussion. We cannot stop only on the financial aid. We have to talk about other types of aid and support. And among those problems discussed by the representatives of our focus groups and the relatives, the members of the families for Crimea, the situation is such that people cannot even get that money because they are only transferred to the Ukrainian bank cards, and the Ukrainian bank cards can only be issued using the Ukrainian telephone number. This is the problem that those people are facing. Previously, the transfer could not be made in favor of persons who act on behalf of the family members of the detained persons. Now there are amendments made to the law, and now the family members of those detained can appoint a person to represent them. We wanted to help one elderly woman, but she had no relatives or friends here except of us, and we as lawyers cannot exercise such a function of a representative according to the law. Also, we have to talk about confirmation of the family ties, because many people, for example, who were detained, they were living in civil marriage, and to confirm their family relations, it's their responsibility. It was previously done through, or it was possible to do it through the courts previously, but it's a very long and complicated and costly procedure. Those amendments that were made recently that I've mentioned, they include among family members who can apply for financial support. Now they include the people who were part of the civil marriages, but let's see how it's going to work in practice. The Commission is going to identify those family ties during their meetings. Also, what I wanted to describe is the reimbursement for legal aid. The amount that those people can count on is a little bit above 53,000 hryvnia to cover the expenses for the legal aid. But if we know the price of lawyer services in Russia, for example, they ask to be paid in thousands of dollars, so those 53,000 hryvnias is not so much to cover those expenses, and the lawyers themselves, they end up in jeopardy. They come in very little numbers in Russia, and we appreciate the fact that they work in occupation to help our citizens. So now there were again amendments made to the law, and they said that people can use any supplementary documents to be submitted for reimbursement. Also, we were sending inquiries to different government agencies about disbursement of financial aid, and I have to emphasize that the financial aid is the only type of aid that people know about. And for example, when Mr. Bohdan mentioned about the legal aid, people almost never know about it, and the government agencies who are responsible for extension of such aid or compensation for such aid, they very rarely publish any information about such responsibility of theirs. Some of the agencies have not even responded to us. The Ministry, for example, of Education and Science of Ukraine said that 5 people entered higher educational institutions using the preferential conditions as the family members of those who were deprived of their freedom in temporarily occupied territories. But again, those people are not segregated as a separate category of population. You know, we mentioned such figures as thousands of people, and we have to agree that the information should be published about all those types of aid, because they need psychological rehabilitation, they need medical rehabilitation. All those coming back from captivity, we know what conditions they end up to, how they are being tortured. They definitely need medical support further on. And it's a huge problem that in fact that the Ministry of Reintegration doesn't track the condition of fulfillment of this law by other government agencies in whom the responsibility is vested for exercising any functions related to extension of all those types of aid. For example, people, as they get out of captivity, they spend all the 100,000 hryvnias for medical support, and then they are not covered by the government. Well, for what I understand, government is also responsible for provision of temporary housing to those people, because we understand they are usually the people from temporarily occupied territories, and as soon as they solve all their problems with medical condition and rehabilitation, yet another thing for them, another pressing issue for them is housing. Do you know any cases when the government extended such types of support to them? Well, we don't have any information about such cases. Usually they are being held by either volunteers or friends, but in fact the government authorities never responded to us in any official way that they support such people in complex manner. So, in your opinion, what has the state to do to improve the services for those who survived the real horrors in their life? We understand that one of the points is about the development of the algorithms to respond to such things that emerge as they apply, but what else? Well, let me start. First of all, it's the awareness of the families, but also we have to appoint a government agency who is responsible for this category, because it turns out so that the commission created at Ministry of Reintegration, and the representative of a Ministry of Reintegration is the head of this commission. But what else is the ministry doing to the civil hostages, to those who were set free? It's unclear, and this is why we didn't get any centralized response about what is being done. So they say we don't count. We've identified some medical institution, but we don't know whether the family members know about the existence of that medical institution. So we have to make a conclusion what doesn't work, and some of the government agencies has to undertake that function. It's better to make a public analysis of what does work and what doesn't work, and it could substantially help us, because frequently we don't have such a practice that the law is adopted and we forget about it. We don't want to have anybody forget that this law is in effect, and if a government agency doesn't respond to us, for example, the people who were set free, they can get a passport of the citizen of Ukraine of international standard to live abroad for free. Like those people, they don't know that they have such a right, and it's a signal for us that this law does not operate, and obviously making citizens aware. I started with this. It's important to emphasize that people should be aware about the existence of this law. We cannot tell them that the law works, and in fact it does not. So on one hand, we have to keep informing the citizens, and then we have to correct the law as in its application. Those standards that are contemplated by the law, they all should work. Well, if nobody has anything to it, let's proceed to the questions from the floor. Good afternoon, Aliona Sobko, Ukrinform. You know, I'm having more of a request to you than a question. We know that many people, many people whose family members were abducted, they don't know where to go, whom to apply to. Could you give some practical advice, algorithm of actions? What are they supposed to do to start their search, to start searching for their loved ones? Also, I'm interested about your position. We know that there is no clear mechanism in place to bring the civilian hostages back, and we know that the Russians frequently act so that if there is no person, there is no problem. They don't even give us the information about them. So what door should Ukraine knock on to find the mechanism of pressure on them? Well, let me start. You mentioned those who were abducted. So first of all, we tell all of the relatives that they should first go to the law enforcement agencies, even if people will further on be found to be prisoners of war, that will already be approved that they were searched for. Also, we encourage everybody to apply to the National Information Bureau and to the Commissioner for the Abducted Persons, and also the Commissioner of the Parliament of Ukraine on Human Rights. It's also possible for them to apply to our civil organizations. We have programs of support. We can also help them in a number of ways. What I also want to add, that there is a huge problem with discerning of the categories of those who were detained due to the armed aggression of Russia and those who disappeared under unknown circumstances, because very frequently the facts of detention are not identified, or facts of imprisonment, and we cannot confirm such facts or prove them. Sometimes people are being abducted, transported somewhere, some people know about it, but there is no documentary proof of that, and it becomes a little bit different. The status of a person who disappeared under unknown circumstances and those who were imprisoned due to the Russian aggression. And let me pass the microphone for another part of the answer. Well, my colleague just mentioned a number of government agencies and civil organizations that family members should apply to. This is what Aliona mentioned, that there is no single window, so to say, where family members can go in case a family member disappeared. They may think they were adopted due to the armed aggression of Russian Federation or due to political motives. In reality, there is no single window, single mechanism, and most likely there will be no single solution to bring all of our civilian hostages back home. But in short, the state of Ukraine has to solve this issue on two levels. First, on the national level, we have to appoint a responsible personnel, some person or agency, who will answer all of the questions of the family members of the civil hostages, where they should apply, and they should also, this agency should be aware of all of the civilian hostages detained, abducted by Russian Federation, both in occupied territories and Russian Federation. I believe those tasks can be solved by the state on a national level to verify the list of such persons, to make it complete, and to try to find and identify all places of detention, and to keep track, at least from the available sources, to keep track of the movements of those people in occupied of abducted people in temporarily occupied and territories and Russian Federation. Now the exchange of prisoners of war is suspended. The last one was taking place in August, but every such exchange is a source of information for different of our law enforcement agencies about whereabouts of both military prisoners of war and civilian hostages. And yet another level is an international level, when Ukraine fulfills some work on international level. We know the list of the prisoners, we know where they are, we know their condition, the conditions of their detention, but we cannot solve the problem with bringing them back to Ukraine. And in this case, dear international partners, we need your support. And we can ask our foreign partners, first of all, to monitor the conditions of detention in temporarily occupied territories, let alone in Russian Federation. And there are such instruments in place. For example, Moscow mechanism of OSCE can be created with such a mandate, or otherwise we as Ukraine can work with other monitoring organizations that may work in the territory of Russian Federation, and to be in touch with all the diplomatic missions in the Russian Federation. Like, for example, an ambassador of Canada could try to attend some civil or court proceedings in Moscow, and then we may start talking about bringing such citizens back. We can say that it's a non-standard problem and we need non-standard approaches to bring them back. But the more information we have, the better armed we are, and the more arguments we have in our dispute with Russian Federation in terms of bringing our citizens back. Miss Aliona, let's try to finalize it. Thank you very much. I think that the state has taken a very important step by adopting this law on civil and social protection of the persons who were abducted due to armed aggression of Russian Federation. Well, it's positively evaluated again by the family members of those people, but again we have to understand what doesn't work in this law and we have to rectify it, because when the family members say that we don't feel any care by the state, it's very painful for us. We have to know that those who were affected by the armed aggression, those who lost members of their families being imprisoned, they have to have some government support. They have to receive government support and they should feel that care by the government. And it's very bad when the government authorities cannot provide any information even about the status of such services, whether they are being provided or not. So as Tanya said, it's important for the state to pay attention to those people, to pay attention even to those people who were already set free and who received such type of aid. Maybe we should talk to them whether that aid was sufficient or not, because the law contemplates support in acquisition of higher education, for example, but many hostages, they don't have even small kids and they don't have understanding what the state can offer to their small kids. So after the law is adopted, we have to monitor its fulfillment and we have to amend certain regulations within this law, and we have to make people aware how they can obtain proper aid and support from the state. Thank you very much for this broadcast. Thank you for working on this important set of matters. It's very important for us as a Ukrainian society. Thank you very much, dear colleagues, for your interest to this topic. I want to thank our security and defense forces, and we all continue working together for our victory. Thank you all very much, and glory to Ukraine.